Uh, it's a great pleasure to introduce Carl Shapiro of Berkeley, who will talk about merger guidelines. Carl, take it away. Give us some overview of how do we understand the merger guidelines, the proposed merger guidelines, and how does this compare to the prior version of the merger guidelines, which you were a primary author of?
Thank you, Danny. Thank you very much. Thank you, Julian, for inviting me. Thank you all for joining here this morning. The Justice Department and the FTC here in the United States issued these draft guidelines about maybe to the day, 3 months ago now, in July. I'm going to talk about what's in them and how I see them, really very much from a U.S. point of view. So my apologies in a sense for that, but that's really what I know best. I'd love to hear from folks about how they think this affects what's going on in your various countries. To what extent there's learning or spillover or whatever from the United States. So let me start with a little context, and some of you may know this well, others less so. So the guidelines, which were first issued in 1968 by the Justice Department, there have been major revisions in 1982. That's really when economics was brought in more seriously with the hypothetical monopolist test for market definition. In 1992, unilateral effects was really brought in 2010, where we built on that and did some other things. And that's the round that I was involved with during when President Obama was in office. So now we have what I think actually will be the 2024 guidelines, although they may sneak in this year. I don't know, 23 or 24. So first, just what is up with guidelines? Why do we even have these things? This is not a standard thing throughout the law or throughout the law enforcement. But I think for the United States, and I won't keep repeating that, our statutes are so broad and one might say vague. What the law says, mergers that may substantially lessen competition are illegal. So what does that mean? And we've got case law that's developed, but the agencies have since '68 found it useful to tell the world how they're going to interpret and enforce the statute. So the guidelines are not law, they're not binding on the courts, but they have been, to me as an antitrust economist, an incredibly influential and positive way, positive influential force in what I think of as a dialogue between the agencies, which have a lot of expertise, obviously experience investigating mergers and challenging some in court, and the courts, which are these are generalist courts, generalist judges, and their typical judge in the United States, handles 0 antitrust cases in their career, or maybe 1, or certainly almost no mergers. So this has been a way for the agencies to inform the courts about how they think about things and influence the law to some degree, and also inform the other audiences for guidelines. And I'm going to get to the draft very quickly now. Besides the courts, it's the public, right? The business community, the antitrust bar, like the lawyers, okay, when we go into the agencies, advising businesses, is this deal likely to fly? Is it likely to get in trouble? Whatever. There's also, it's internally, it's very helpful to tell the staff, here's how we investigate things. When a new attorney shows up, or economist for that matter, you give them the guidelines and they read it, and they that's important. And then America being itself, of course, we think maybe we can influence the rest of the world, or part of an international discussion as well. So there's various audiences. And I wrote a paper about 2 years ago now with Nancy Rose, who's at MIT, also former chief economist at the Justice Department, about what we thought these guidelines should do. It's been in July 2021, President Biden issued an executive order about promoting competition policy generally. And in that, he called for revised guidelines. Nancy and I quickly figured, all right, we're going to see revised guidelines. We wrote this article. All the stuff of mine that I'm going to talk about is up on my website at UC Berkeley, easy to find. So we identified, this isn't new to our article, three guiding principles, through three, let's say, principles that all previous guidelines have sought to follow. One is it's a law enforcement exercise. So you're telling the world, I'm imagining being at an agency, DOJ, FTC, you're telling the world, here's what we're doing, but it has to be consistent with the law, by which I mean the case law. Okay, because when you go to court, that's what the judges look at. DOJ, FTC, they're this law enforcement exercise, so it has to be consistent with the case law, and I'll just call it the law. That's one thing, law enforcement. The second principle is transparency. You want to tell people what you're actually doing as clearly as you can. That seems like a good government principle. And the third is new learning, which is as economic learning grows, as experience grows, as the economy evolves, these general statutes, it's one of the virtues of antitrust law generally, in my view, is it's flexible and can adjust on a fact-specific case-by-case basis to different markets and developments. Okay, so new learning. So that's what's always, all the previous guidelines have been, when they're updated, it's be consistent with the case law, tell people what you're actually going to do, and reflect new learning, so we move things forward. Okay. Now, the current draft, I think, does not score well on two of these dimensions. Well, let me say 1.5. First, transparency. This seems to be, so the draft guidelines get issued 3 months ago. I'm not going to go through a detailed summary of them, okay? But I'll refer to elements. From what I understand and my own knowledge with these things, personal knowledge, they accurately describe what the agencies have been doing over the last couple of years since Jonathan Cantor took the helm at the Antitrust Division at DOJ and Lena Khan at the FTC as the chair. So transparency, and I have no reason to think that's not what they will do in the future. So I figure, okay, that's good. Since they are doing things quite differently than in the past, it's a very good thing to tell the world about it. So it's not just inside folks who live in Washington and have dinner with people who work at the agencies who know what's going on. Okay, so transparency, fine. I have no objection. Of course, that doesn't mean it's a good thing they're doing. It just means they're telling the world accurately what they're doing. Then the others are law enforcement and new learning. Let me go to new learning. There are definitely elements here. So the context in the United States, there's a very political context and an economic context. So, for example, I guess there are 2 or 3 areas where there's really new stuff in the guidelines that reflects how the economy's changed, how our debate has changed, and so what I mean by that, and the main things are the platform. One of the guidelines, guideline 10, there's 13 guidelines listed specifically. Guideline 10 talks about how the agencies will evaluate mergers in multi-sided markets platforms. And of course, we're all thinking about whether it's Google or Apple or, they're thinking of big tech, which is very much in their sights, but it's not just big tech, right? It could be financial platforms, it could be other trading platforms, et cetera. So they have, and Susan Athey, who's the chief economist at DOJ, is fantastic economist. She's worked on this very extensively, I know, on those topics. So she's very well placed to do it. Aviv Nevo, who's counterpart at FTC, they've both been very heavily involved in this, and so there's an element of new learning which Nancy and I and many others said that should be included in the guidelines. For example, what do you do in a market where the consumers don't pay anything? It's free. It's a free service and it's advertising supported. This is not a entirely new issue. We had this in radio and newspaper mergers for 75 years, 100 years maybe, for newspapers. But laying it out, I think it's quite useful and pretty well done. So that's some new learning. The other new learning would be labor markets. So the Biden administration has been very interested in competition among employers to hire workers, and that not be stifled. So you've got a section on competition mergers between employers that might harm competition to hire workers and therefore hurt the workers by giving them fewer opportunities in terms of where they can get their jobs. Politically, very, very a winner for the Biden administration. It's not so much new. I mean, we added a section in 2010 on mergers between competing buyers, right? Mostly we talk about mergers as competing sellers who are merging. They're going to raise the price, whatever. We added a section about mergers between competing buyers who could then have monopsony power or some sort of buyer power would be enhanced. But we didn't specifically talk about labor. So there's a whole thing on labor. And I think that's a good thing. There's been a lot of interest in that. I'm still somewhat skeptical that there will be many cases involving mergers that the harm is in the labor market as employers merging rather than in downstream markets for products or services. But they're spending a lot of resources on that. I'd have no problem with them laying out how they're going to do that. Again, I think the jury's still out. It's still too soon to say whether that will lead to much enforcement action. Okay, we haven't really had those cases yet to speak very much at all. So I've been skeptical about how much it's worth devoting resources to that. And I'm curious in other countries whether you think you could do things to help workers to protect competition in labor markets, or whether that's not really where the action is when you do merger review. Okay, so that's new learning. And there's some other things, but those are the main things. I would say there's some stuff on potential mergers involving potential competitors that I think was a good addition that was missing in a way in 2010. But there's not particularly new learning there. It's kind of filling in a gap. But those are sort of three areas where I'm positive about what has been added. But overall, I'm very concerned. Okay, so I've had this wind up now, but I'm going to tell you my worries. As you may know, there was about I think a 60-day comment period. So there's been many comments filed on these by the public. I submitted my own recommendations for changing them rather than wade through the 5,000 comments on the FTC website. You can go to my website and at Berkeley, like I said, and find my comments. The Fiona Scott Morton at Yale, through her Thurman Arnold project, they have a curated set of some comments. That's also a good place to look because it's hard. There's so many thousands of comments in the official website. It's hard to navigate. So I have my comments are express a lot of concern. And so then we lay out the concern, and then I'll do that a little bit. And then Danny, I think maybe we could have a little more of a dialogue. So a little back and forth, see where you think you want to go with it. So the concern is at several levels. And I don't know how much this is going to affect you again in Argentina or other countries. But as somebody who's very interested in effective merger enforcement, I'm concerned. And I have concerns at sort of three levels that I emphasize in my formal submission. First, the law enforcement piece, which I've been holding out of the three things, right? The transparency, new learning, law enforcement. The guidelines score rather badly. And this is a fundamental problem in that they seem to be designed to be a statement of what the agencies would like merger law to be rather than what it is. And that's all fine to give a speech that says, okay, we think we need to move things in this direction. Maybe you try to encourage Congress to pass legislation, whatever. But as a guidelines of how they're going to enforce the law, it's really important that they not stray far. Let's just say they be really consistent with the case law, even while they may be trying to move it in certain directions, which I think every round of the guidelines is trying to move the law, but it has to be consistent with principles in the law. So that's my primary concern, or one of several about the guidelines. Now, why do I say it doesn't score well on the law enforcement dimension? So now we'll get a little bit into the weeds. All previous guidelines have been I would say statements of economic principles. Here's how we think about the economics, what we measure, typically market shares, define markets, but unilateral effects, what we're looking for. It's all, and they have stated, it's all been economics, and rather amazingly, there have been no case cites. It's not citations to cases. The authority of the guidelines has always come from articulating economic principles in service of the law and in service of the law, the statute, and consistent with the case law. This draft is a completely different creature. This is nothing like what we've seen in all the guidelines going back to 68, all the merger guidelines, in the following sense. It's basically a legal brief, okay? By which I mean, it's a series of propositions about here's what makes mergers illegal. And it's got, I don't know, hundreds, I mean, not hundreds, maybe many citations to cases. So it claims authority or gets its authority by saying, here's what these cases said. And so we're channeling that here. So at some level, that seems pretty natural. Like, well, it's a law enforcement exercise. You should cite the case law and explain what you're doing is consistent with the law. The problem is it's not a very good brief. Okay, as Doug Melliman said, who I have great respect for, it's like writing a legal brief in a case and not addressing the cases you don't like, or the parts of the cases that you do cite that you don't like. Okay, now I'm not a lawyer, so I don't really want to get
Carl,
too deep.
can I just interrupt there for 1 second?
Yeah.
We literally just saw that in the Microsoft Activision Blizzard decision, where the judge actually writes, just because you say it so does not make it so.
Right.
If ever there was a harsh rebuke for exactly what you're talking about, there's the judicial language.
Right. And in fact, that's a good example, potential competition, which that case was about. The agencies have a very pro-enforcement view of potential competition, which I'm kind of lean towards myself, but that's not where the case law is at. So, what do you do? Now, in 2010, when we were doing this, we worked very hard to how can we, consistent with the principles in the case law, move things in a more pro-enforcement direction? And this draft just basically takes a view that the law is already where we want it to be, or they imagine that it is, and so then they go charging forward. So I should say, maybe I should have said this at the very beginning, I am a believer in we should have stronger enforcement in the United States than we have over the past 25 years for horizontal merger enforcement. Full stop. Question is how to get there. And I've been pushing for that for 25 years in my writing. All my testimony in mergers has been on the plaintiffs, basically the government side. I've done quite a few of that, and in my advocacy, and et cetera. So the question is whether this draft is going to achieve that. So my concern is twofold then, because the draft is based on these cases, and it's, let's say, highly debatable whether it's a fair reading of the case law or not. And in particular, I should say, the move is in the guidelines is to cite to a lot of 1960s era Supreme Court cases that have not been overruled. Brown Shoe is the main one, or it's the central one. And I will say ignore decades of subsequent law by circuit courts, sub-district courts, and Supreme Courts in non-merger cases, which sends us a lot of strong signals about how the courts. Now, based on Lena Khan's writing, if you think the courts have gone screwy, off the rails for 50 years, and what Congress meant in 1915 and 1914 was something else, and the Supreme Court got it right in the 60s, you say we want to go back to that. And that, I think, is what at least she wants to do based on her writings and speeches. Jonathan Cantor, it's a little less clear, but maybe. So the thing is, I just don't think it's going to work to do that by citing the 1960s cases and saying, well, that's the law, so that's what we're doing, and ignoring a lot of other stuff that they don't like. So that's the problem. And then in terms of what that means for merger enforcement and the economy, I distinguish very sharply horizontal and vertical. Okay. You may have been thinking, I've been thinking the last 15 minutes primarily about horizontal merger enforcement. And I said quite carefully, I'm in favor of stronger horizontal merger enforcement. And of course, the 2010 guidelines are horizontal merger guidelines. So in the horizontal area, my concern is, since I'm looking to strengthen enforcement in that area, that these guidelines will actually not achieve that and could undermine that goal because they're a missed opportunity to build on what's done before. And the courts may very well not accept them, et cetera. So in horizontal area, I want more enforcement, and I'm concerned this is a missed opportunity. In non-horizontal, so these merger guidelines cover, unlike basically all the guidelines I listed, certainly since 92, 2010, were just horizontal merger guidelines. These draft covers all mergers, horizontal, vertical, diagonal, whatever. And my concern for the non-horizontal is quite different. I just think they're likely to get in the way of, interfere with, I'll use that term, interfere with a large number of pro-competitive non-horizontal mergers. And the economics in some of the guidelines, individual guidelines here, particularly, there's 5, 6, and 7 are the ones that address non-horizontal primarily. 6 and 7 are very dubious at best. I criticize 7 quite harshly. We can get into the specifics of what that means, but at this point, I'll just say I think the companies considering non-horizontal mergers, many of which could be quite beneficial, will be facing greater risks with these guidelines enforced than they have been, and I don't think that's a good outcome. Danny, let me pause there, see which of these threads you want to pick up on.
So there are a number. I'm going to go maybe start in reverse order. So in terms of what do companies think? Yesterday in the New York Times, for example, there was someone who was against a vertical merger, Exxon buying Pioneer. And one thing that they wrote in their op-ed, this is not a competition economist or competition law professor or practitioner. This is somebody else who said, it's really great that we just see the agencies aggressive, because simply bringing cases for the sake of bringing cases is going to be great because it chills businesses from doing deals. And some of the critiques overall of the merger guidelines fall within that vein, both for those who support and those who are deeply troubled by the merger guidelines, saying the current draft of the merger guidelines, and done indeed with changes to the HSR policy, are basically put into place to be anti-merger, because we don't like a merger, we only like potentially organic growth, although even there, given that this is an anti-monopoly movement, it's not clear that we actually want organic growth either. Carl, how do we understand these kinds of broader political tensions? I think this is helpful because the broader political tensions are certainly something we see in Latin America. And I think we've seen a lot longer in Latin America, because the breakdown of the Washington Consensus in the early 2000s, we saw first at the macro level, then on the micro level. In the United States, we've had some macro breakdown, and I guess this is an attempt at micro breakdown, but it's not clear that it's going to hold. So this is a very long statement in the form of a question, but I wonder if you could respond.
So I guess in each country where you're all from, I would encourage you to ask yourself, you probably have, what effect do you think mergers have had on your economy and your citizens, your population? And would you distinguish between horizontal and non-horizontal mergers? Okay, I make the distinction because as an economist, it's fundamentally different. Horizontal mergers, the competitors are joining, they're not going to compete anymore, and that inherently is at least worrisome. I'm not saying all horizontal mergers are bad, but we understand very quickly how that can lessen competition. Vertical, not nearly so clear. There's a lot of reasons we want companies to compete at to cooperate at different levels of the value chain, and vertical mergers can facilitate that. So ask yourself, has there been a bunch of mergers that have worsened income inequality, that have led to higher prices, that have led to less variety or diversity, less resilience in your country, whatever, okay? In the United States, there's been a healthy debate, growing debate over the last 10 or 15 years about the effect of mergers. I've written about this, as a scholar as well as a practitioner. I'm very into this. I keep writing about it. And like I said, I think we have not been tough enough in the United States on horizontal mergers, but I don't think it's a dramatic failing. It's more of turning the dial in the more pro-enforcement direction. And I don't think there's much evidence that other types of mergers have caused problems in general, and they often are beneficial. You look case by case. So that's the context. But the people that President Biden has chosen to put in power at the FTC and DOJ are very much taking the view that we've had really a lapse of merger enforcement for 40 years, they say, quite dramatically, and it's led to all sorts of ills: concentration, market power, bad for workers, all sorts of things. I think they vastly overstate that case, but that's their belief, that's their position. And we're seeing that reflected in their policy, which is, again, now picking up more specifically on your question, Danny, is quite hostile to mergers in many respects, okay? A great skepticism that mergers do much of anything good. Skepticism about merger efficiencies. And these companion change of policies to greatly increase the filing requirements when companies have to notify the government under the Hart-Scott-Rodino Act. I think a lot of people have interpreted that as basically a broad-based way to try to slow down merger activity. Okay. And of course, we can debate, well, is that good or bad? My perspective is, I think that's rather broad brush, by which I mean, I've been working for decades on what I call a more targeted policy. We want to identify the mergers that are likely to cause problem and stop them, but let many others go through. And the reality is only 3% of the mergers that are proposed and notified to the government get second requests, if I remember the numbers right, typically year to year. So I think one can read the draft guidelines, Danny, as reflecting a position of the Biden administration that is very skeptical of mergers and trying to chill a lot of mergers. Maybe you use that term, chill mergers, knowing that, yeah, maybe you'll sweep up some benign or possibly positive mergers, but by and large, you'll be stopping activity that's bad. And if you can't really do this so well through the courts, either because the courts are not very sympathetic or because you only have so many resources, so you can only bring so many cases, you can do it through other means, such as telling the world, we're going to be skeptical of mergers. You have to have heavy filing requirements. There are things that can be done in the administrative state to discourage mergers. And I know, and I think you do too, Danny, from personal experience, there are a lot of conversations going on in boardrooms where companies are considering mergers that their lawyers are telling them, well, in previous years, I would have told you this has very low risk. You can go forward. Now I have to tell you the agencies may sue you. You have to be prepared to go to court. It could take a year or a year and a half to close your deal. And this may be a non-horizontal deal that you would have thought would have been waved through before. Now there's no early terminations, right? You can't get through quickly. So it's just more costly, more risky. And some deals will no doubt be dropped. And again, we will all may differ on whether we think that's basically a good thing or not. I tend to be a pretty strong rule of law sort of guy. So I think, well, I really think the agencies in any part of the government should be enforcing the law and not like going far beyond that, just with their administrative powers, for example, to, raise costs just through investigation and filing. But of course, those are tools at their disposal and they're using them. So go back to the draft merger guidelines, Danny. This is why my concern is that in the non-horizontal area, you read these guidelines and a lot of deals could get swept up. I mean, one type of deal is where a company that has more than 30% of let's call it its home market is buying a company in another market, an adjacent market, okay? Maybe it's Amazon buying Whole Foods in our case, for example. Amazon got this online and they want to enter supermarkets. According to these guidelines, the agencies will view that as illegal if the acquiring firm is likely to grow or get more than 30% in the new market as a result of the acquisition. So to use the Amazon Whole Foods example, maybe they buy Whole Foods has 20% in some local area for supermarkets, and Amazon's going to grow that to 40%. That, according to these guidelines, would be an example of extending a dominant position, that's their language, from one market to another. And I'm like, wait a moment, that sounds like a pro-competitive situation. So now maybe if you're doing a deal like that, the companies will say, look, they won't really sue us because they'll lose, or they won't really sue us because they'll come to their senses or whatever. But it's out there. If this draft is finalized with the same language, which I hope it won't be, at the very least, you've got people considering that sort of merger. Their lawyers are telling them, the agencies, on their list, it looks like they could go after you. I think you'll win in court, but it's a risk. So that I think is unhelpful. But it's consistent with the view that they're trying to chill a lot of merger activity in which large firms get even bigger.
Carl, I'm going to open it up, but before I open it up, I'll just give the kind of example of what you're talking about from a different antitrust enforcer, just to give a sense of the politics. Whether or not she said it in her personal capacity or in her her government official capacity, I don't know. But this was at the 2023 Bill Kovacic antitrust salon. We all know Bill. Carl, you've written with Bill. Julian, I believe Bill has spoken more than once to the Foro. So Paula Blizzard, whose official title is Senior Assistant Attorney General for Antitrust in the California Attorney General's Office, which basically means the lead antitrust enforcer, said specifically to the 30% market share cap, the following, and I'm quoting literally verbatim, and I'm happy to actually have a voice clip sent to anybody else. She said, maybe a corporation is stuck at 30%. You do not have an unlimited ability to make more money in this country just for the sake of making more money. The message of these merger guidelines is you need to tell your clients to not have so many mergers because the country is not going in the right direction, end quote. So I mentioned this to you because even if this was in her personal capacity, and then I'll open it to everyone, things that you've heard aspects of in Latin America, as well among populists. Getting an echo. But what I'd say is, Carl, I think this is all of your fears about the populist entry into sort of the underpinnings of merger control. Here we actually have a government official, let's even imagine in their personal capacity, articulating this. Maybe with this, good, we already have questions, and ooh, wonderful, we have questions from two former agency heads, Hannah and then Felipe and then Esteban. Oh my God, we've got like an all-star cast, Chile, Argentina, and Mexico. Hannah, why don't we start with you? You're on mute.
Is it me?
Yes. Yes.
Hi, everybody. Thank you so
Hi.
much, Danny, for organizing this, and thank you, Carl, for your remarks. I wanted to ask, so what would you have liked to see in these merger guidelines as to make horizontal mergers harder to pass? I mean, if that worries you and sort of worries everybody, what would have needed to be within this merger guidelines to make this happen? That's one question. And then the other question is, you ask about Latin America and our view in
We lost you there.
vertical
Go
is that many of the
We
big
lost you there. Go on. Okay, continue.
my experience in Mexico.
Continue.
Yeah. So my experience in Mexico is that many of the large companies, they have they also control either the upper part or the lower part of the value chain. So vertical mergers, in my view, sometimes do generate bottlenecks and are more complicated than what the people in the US say. So I sometimes really do ask myself if they are really so pro-competitive as the antitrust community thinks in the US.
Okay, great. Great.
Carl, I was going to say,
major echo.
Yeah, maybe because we have so many questions coming up, maybe I'll just take this group of 4 first, have all the questions, and then you can respond in total to all of them, because I want to get in as many of these insights as possible, only because actually, no, I take it back. We have 20 minutes left. You can go one by one. Go one by one.
I think it's better, Danny. Okay. So on the horizontal piece, so Nancy Rose and I, in our article, we laid out a number of specific suggestions for doing exactly what you asked about regarding making horizontal merger enforcement stronger. The way I see it, again, having testified a number of times for the government and been in the government as chief economist at DOJ twice, the way in the United States, at least, the government wins, given our system, is by defining a relevant market, showing that the shares are high enough, the concentration's going up to get the structural presumption, and then telling a story around that about how the merger really is reasonably likely to cause some harms. Okay, those are the pieces: market definition, shares, story. Story could be coordinated effects, unilateral effects, whatever. Okay, so the way that I'll say we, Nancy and I, say is, there's a number of things the government can do in the guidelines to assist it with market definition. Sometimes the government loses what I think are meritorious cases because the court doesn't agree with the market. The hypothetical monopolist test is a very powerful tool, and so because it often leads to quite narrow markets, which helps the government. So there's ways to tighten that, to make that a stronger tool, they didn't do that. If they went the opposite direction in these guidelines, which is they said, well, the hypothetical monopolist, that's one way to define markets. There's 3 others. And there's a whole bunch of things they actually went the wrong direction. But anyway, to answer your question, you could say more about narrow markets, and in particular, the connection between unilateral effects, and be bolder about how if you have 2 firms and they're merging and you think will have the incentive and ability to raise price simply because they're not competing against each other anymore, then according to the hypothetical monopolist test, the 2 products they sell form a relevant market, satisfy the test, because the merger itself will lead to a price increase, and that's the test. So there's a bunch of ways to strengthen that. One can lower the HHI thresholds, which they did. We raised them in 2010. But I have a whole bunch of data. It's in my submissions. It's in my work with Howard Shalansky that shows the agencies are not bringing cases that are anywhere close to these thresholds. So I actually don't think that's a particularly effective way to strengthen things. I don't object to it. I'm lowering it, given we have some accumulating evidence. But the main thing is to work on market definition and to also make even clearer that some of the defenses that are used, particularly entry, there's been some very nice work by Nate Miller at Georgetown and others showing how entry, it's very hard. Basically, if entry is really going to be easy, then the merger is not going to be profitable unless it generates a lot of efficiencies. So if there's no good efficiency story, the entry story is problematic. So there's those are the answers to horizontal. On the non-horizontal, I agree with the thrust of your question, which is if you have a company that has a bottleneck, a real dominant position at some level, that's exactly the circumstance where we might worry about them acquiring somebody at the other level, because they could use their bottleneck to disadvantage rivals at that level, or they would force two-level entry to compete with them in the future. These are well understood theories. And guideline 5 in the new guideline, the draft, goes through that. And I've testified in a vertical case. So we have a framework, the economists have a framework that works well. There's progress that needs to be made. I mean, the court agencies haven't done well in court on these deals, so one could talk about that. But the reason I'm objecting is I think the concerns you're identifying can be addressed through that guideline. The other two guidelines, 6 and 7, are really pretty out there. I don't think well supported in terms of the economics, and undermine the credibility of the whole document. So I don't think you need them in order to go on a case-by-case basis. You said something like, oh, Americans tend to be very positive about vertical mergers, maybe too much so. I'm not that in that camp. I think it's very case-by-case. And so the good guideline here will show how to identify whatever number of vertical mergers are problematic. I will say I advise the agencies not to combine vertical and horizontal in the same document. Horizontal mergers, we really know what we're doing. We have a lot of case law. We have decades of guidelines. It's rock solid stuff. And vertical is kind of wild and woolly, and we're back and forth. They updated those guidelines in 2020, but it was controversial. Now they're going very differently from that. I think it takes away from the force and strength and stature of the horizontal merger guidelines to put them in the same document with this much more controversial area. Let's just put it that way. That's not as well worked out in terms of how to do it, and certainly in terms of the case law is very thin. So. But you shouldn't interpret my previous comments to suggest that all vertical mergers are fine. It's just we have guideline 5, which is basically incentive and ability to foreclose, raise rivals' costs, that sort of thing. We've got a way of doing that, and the other parts here are problematic. Next question.
Felipe.
Thank you. If you Carl, you can go deeper on the numbers. I'm worried about guideline 1 and 6, and the reduction from 2,500 to 1,800. And in addition, I can read that there is a 30% market share, which has been introduced in the draft. And in verticals, as you mentioned, there is a 50% foreclosure share. So again, you said something before, but do you agree with these numbers? Are so important? And if so, should you think that these numbers be somehow transplanted to other countries with the small or medium economies? And also, do you think will the U.S. agency be able to review this market share, especially efficiently, because probably it would require a lot of work, I mean, to calculate and to be sure which is the real market share. Thank you.
So I'll pick up on first on what your last comment. You can only measure market share once you've defined a market. Okay. So all of this concentration stuff is, follows from market definition. In practice in the United States, and I'm pretty sure it's true in all of your countries too, you kind of take your best shot at like this looks like a reasonable market. Here's where we can measure stuff. Maybe it's a retail market. You look at, grocery sales and you draw some different circles. So it's a practical, realistic exercise. I think, so you do your best to measure market shares. We're going to need to do that because you do need this structural presumption. And I think it's true around the world. It's hard this is how the government in the United States and elsewhere, I think, shifts the burden, establishes its case that there's likely to be a problem. And it's been absolutely fundamental to merger enforcement in the US and I think other countries. Herba and Kamp and I have an article about this. So I'm very big on the structural presumption. You have some economists and others who say, there's no strong evidence about the relationship between concentration and competition. I think I don't accept that, okay? But do we know what level things kick in at, 2,500 versus 18? We don't. I mean, we probably have better merger retrospective evidence in the United States than just about any other jurisdiction. But it's very thin. I think this is one of the areas where I criticize the Biden folks is they seem to think, oh, we know there have been all these terrible mergers. And there's definitely a bunch of mergers, particularly in the healthcare sector. I mean, we can go through examples. There are examples, but there's not evidence that it's widespread throughout the whole economy in terms of mergers that have been horrible. There's a bunch, okay, don't get me wrong. That's why I think we need stricter enforcement. But and in particular saying, oh, we know that once you get above 2,000, that's when we really see the problems, and we just don't have that evidence, okay? So we have never had that evidence, okay? And of course, it all goes back to market definition too. So like I said, my issue with the 2,500 to 1,800 shift back is, and this I'll admit, it's affected by what I was part of doing this, raising the thresholds in 2010. Why did we do that? We didn't do that to weaken merger enforcement. We were about strengthening merger enforcement. We did it about transparency. We looked at the data and we said, look, the government is not challenging mergers that are, 1,800, 1,900, 2,000. We're just not doing that. So we shouldn't tell people we're doing it unless we're going to start doing it. Okay. And we didn't think we could do it. I mean, I have data in my submission on, in my work with Howard Jelansky that shows that the merger challenges, the Herfin dollars are typically like 4,000 or 5,000, So this is not where the action is in terms of real enforcement. I don't mind if they lower them, but if they lower them, then they should start enforcing down to 1,800. I don't think they're going to do that between resources. And those are going to be cases that are going to be hard to win because in the US, we have a sliding scale, meaning even if you get your structural presumption, if it's 1,850, it's a weaker presumption, okay, than if it's 4,000. So I just don't think that's the way to go. But if they want to go there, that's fine. But I'm not sure they have the resources. So I'm concerned they're going to lower this thing, and it's just going to increase the gap between reality and what the guidelines say. And that violates the transparency principle. The other thing you brought up, the 30% share. So just to be clear to everybody, these guidelines call a firm, it says a firm has a dominant position if its market share is more than 30%, and then that triggers various things, such as extending that or entrenching that position. So a couple things about that. First off, way to go, Latin America, Europe, you got dominant position has been imported by the United States. So you win on that one. Congratulations, because, rather than monopoly, dominant position, which I think, Danny, is basically not in the US law. Dominant position. Anyhow, it's very much, I think, with European roots, and I think then has used elsewhere. But then more important, 30%, like, whoa, that's interesting. I didn't know. In the US, we think about monopoly, right? So I'm like, I don't think of a firm with 35%, let's say, as having a monopoly or a dominant position. But okay, whatever you want to do. But then you go, well, where's the case law support for that? Hence my point about law enforcement. Like, they can say 30% is a dominant position that triggers these things. Maybe I would like that for horizontal. It would strengthen their hand. But if there's no case law, they're like far out of bounds of the case law. What do you think is going to happen when they go to court? What's going to happen is a judge is going to say, look, I got the case law here. You've got some guidelines which indicate some position, but that doesn't seem consistent with the case law, so I'm not going to really pay attention to that. That's not good for the guidelines. One of the things that Howard Chalansky and I showed in our paper is over the past 20 years, we read all the decisions by the courts. In none of them did the courts say, oh, these guidelines, inconsistent with the case law, I'm not following that. They didn't agree with the government in every case, but they accept the guidelines as a framework. And the merging parties generally almost uniformly accepted the merger guidelines as a framework and said, we win under the guidelines. Because the guidelines were like economic principles, you look at this, you look at that. And they say, fine, we'll do that and we win. So it's not like the government was conceding the case, but the framework was accepted by the courts and the merging parties. I don't see how that's going to happen with 30% dominance. I don't imagine any defendant is going to say, okay, well, we got 30%, so we're dominant. Why would they say that? They would be kind of malpractice for the lawyers to say that, given the case law. So we've got this danger, rather strong danger, that the guidelines will be explicitly rejected by the courts. And that's what I meant by a missed opportunity. And the 30% is a good example of that. Okay, next question, so we move it along.
Esteban.
Thank you. First of all, I have to recognize Carl's work. Thank you for your work on differentiated products and all this stuff that gave us a lot of tools for agencies, and we try to reflect your work in our guidelines also. But I have thousands of questions, but I will choose only two, and you can dismiss the first one that is very specific, because I wonder if you know how to understand the coordinated effects theory of harm under the new draft guidelines. But maybe the more important question for me is about your thinking of, we have been the last, in my case, almost 20 years or more than 20 years, learning and understanding case law and enforcement from US. We really, I think, from Latin America, we pay attention to your guidelines, to your case law and enforcement. And we were learning about efficiencies and how effect analysis is important, and how to take into account contestability in different cases, and how to understand that the structural conduct and performance paradigm approach is really complex, and how the feedback effects we have to take this into account. But now, maybe with all this debate, it seems like all that we learn is is wrong or maybe misguided. So you are confusing us. Do you know? I think you are adding to the general confusion. So with all this debate, so I think all this debate, it seems like there is a big change in the approach in the enforcement, but really in practice, all this noise what is the impact of this in enforcement and case law? After all, it will change really much the enforcement of and the merger cases and justice and the practice. We have to take into account all this noise in our thinking and in our practice, or maybe we just are going to teach in United States about dominant positions, that because we know more about this concept than you, but the question is, which is the practical impact of all this discussion?
So first, when you said, quote, "You are confusing us," I hope you meant the United States and not Carl Shapiro. Okay.
Yeah.
I think you did. So look, those of us who've been doing antitrust in the United States for decades, like me and many others, Herb Hobenkamp's a good example on the legal side, we've been dismayed at the rhetoric of the Biden administration, because what they're saying is, we, the United States, have gotten this badly wrong for 40 years. We need to dramatically change to fix those problems. Okay. So first of all, I don't think that's true. Okay, in terms of, I just don't think that's true or supported by evidence or economic logic or legal reasoning or whatever. But the consequence naturally, and look, this is not just these guidelines, this has been agencies' speeches and so forth for a couple of years now, is I would think the rest of the world, Latin America, here we are today, here represented, says, wait a moment, we were kind of following you for a while there. Are you saying that we followed you in the wrong direction? Like, are we supposed to then, what? Okay, hence the confusing. So, and I'll have to say, I remember in the 90s, I was first at the DOJ in the 90s, and we spent a lot of time as an agency working with Eastern European countries who were trying to set up competition authorities after the fall of the Iron Curtain, right, and the collapse of the Soviet Union. And I worry now that they and other Europeans say, wait a moment, you taught us to do these things. Are you saying you taught us all wrong? So my view is, no, we've basically the message has been a sound one. It varies a little bit, Republicans, Democrats, whatever. And so I don't agree with the current rhetoric, but I think it's quite understandable that you, and I doubt probably other people on the call, like, wait, is this noise? Should we listen to you? Whatever. And I think this is not just about these guidelines. I mean, this has been a consistent message, quite a consistent message, since Lena Khan and Jonathan Cannon have come into power at the agencies 2 years ago or so. So my message is, and I say the same thing, by the way, to students here at Berkeley who are figuring out, what to do in industrial organization, PhD students, I mean, especially, is look, there's a bunch of politics coming in. There's a bunch of rhetoric that's overheated. Don't go for it. There's some, listen carefully, that's fine. But the notion that somehow everything's been done wrong for 40 years and we got to change it, it's not correct. Don't go too much into that noise. Okay. And look, in terms of the effects, in the US, unless they convince Congress to pass new antitrust laws, for very good reasons, antitrust as a common law, case law body, it moves slowly, right? The judges, they have a lot of precedent, and it's not going to do, I mean, look, probably the effect of what the Biden administration is doing will move the law to some degree in the direction they want. So far, they've been pretty unsuccessful in court. But, think about things will be like in 2 years or 4 years. We'll still be doing this. I hope I will, and I expect you will. No, we're not going to have a dramatic change in the United States. And so a little more steady as she goes. Don't follow this. On your coordinated effects point, I'll just say quickly, this is another example where the guidelines are trying to lower the bar that they have to clear. We struggled with this in 2010 in terms of what would we want to show to convince ourselves at the DOJ or a court that coordinated effects are a real problem, apart from concentration. And these guidelines basically say, well, if it's concentrated market, we've got a problem. And then, here's some stuff we look at. I'm going to look at it now. High concentration, prior attempts to coordinate. That's always been key things. If concentration is high, you attempt. But here's an example. Suppose they attempted to coordinate and failed 4 years ago. Okay. My view is, well, maybe that shows it's hard to coordinate. Okay. But these guidelines say, well, if you tried, then that suggests that you think it's a real possibility. And now the market's more concentrated. So that's going to make us think it's a problem. I don't know if courts will buy that. It seems kind of like heads I win, tails you lose. If you attempted to coordinate, if you succeeded, okay, we get it. If you failed, that still counts again. That's not so clear on the logic. So they're trying to make it easier. But the three primary factors: highly concentrated market, not a question. Coordination in the past, not a question. Failed attempts, not so clear. And then elimination of a maverick. That's the same stuff we have. Okay. I think what they're doing, and again, this is throughout the whole guide, is trying to reduce what they have to prove. To say it's not, we don't have to look for very much, we're going to see a problem. And they hope the courts will go along and agree that with the structural presumption, they don't have to tell much of the story. This is a big question when they go to court. Look, when they go to court, they're going to tell a story, because if you don't tell a story, a judge is like, what's the harm? What are you talking about? So they're going to tell a story, and they're writing guidelines to make it seem like, well, we don't have to tell much of a story because the structural presumption gets us there. That may or may not work. We're a little over, Danny. What another question?
I think Germán's been very patient, and that speaks very well to UCLA and his training there. Germán?
Thank you very much, Daniel. Now, my question goes back to the non-horizontal merger case. It's true that in the United States, merger guidelines designed for non-horizontal mergers, but in other countries, there is considerable experience with that. For example, in the European Union, do you know if these new US guidelines related to non-horizontal mergers are somehow compatible, or were inspired, or they follow more or less the same lines that are already in place in Europe or in other countries? Thank you very much.
I'm not entirely sure, Germán, but I'll say there's 3 guidelines that cover non-horizontal, essentially 5, 6, and 7. 5 is an incentive ability, kind of will you have an incentive to raise the rival's costs or foreclose them at the input? Very standard stuff. This is how I've analyzed and testified about vertical mergers. I think that's common in US, Europe, elsewhere probably. So that one's not a problem. To me, that's got good pedigree. My criticisms have to do with 6 and 7. So 6 creates a structural presumption if one of the vertical merger, if the market share is above, I think it's 50% at one of the levels, 50%, then it's presumed there'll be a problem. Okay, that I don't think has good economic pedigree or economic basis. I don't actually know whether that would be whether we would see elements like that in Europe or Latin America. I don't know the answer to that. Good question. Maybe somebody else knows the answer to that. The third guideline is guideline 7. This is about entrenching or extending a dominant position. So extending, acquiring something else, like my Whole Foods example, or potentially buying an input that lets me be more efficient and gain more. Let's say I have 40, 50% of the market, and I buy something that makes me more efficient, and I get even stronger and even harder to compete against because I'm more efficient. This would be counted as entrenchment and be viewed with suspicion under these guidelines. And that seems problematic to me. It's a form of efficiency offense, or it can be, as some of us have seen in Europe in the past, which economists do not like. So that, I think, if we see it elsewhere, it's something that other countries have learned not to do. And hence we get back to the point such as Esteban made about, wait, are you telling us when we followed you, the United States, that now you're saying we shouldn't have done that? But no, I think counting efficiencies against a firm just because the firm's already, say, large or powerful, it's a mistake. It still is a mistake. But we see elements of that here. I don't think that's being done well. To the extent that's being done in other countries, I don't like it. And it's quite a departure for the United States to go in that direction. I don't want to keep people too long, so you decide.
I think why don't we take one last question from Amanda, and then we will have a permanent injunction on further discussion.
Sorry to be the last question, and thank you, professors, for the time. My question would be the following. The US had at least 3 defeats on the last years on vertical cases. For instance, AT&T Time Warner, United Health Change, and now Activision Blizzard. At least the 3 of them may be considered, I don't know your opinion, but they're a defeat of the DOJ and FTC attempt to block vertical mergers. And my point is, considering that we have now the merger guidelines, at least in public consultation, would, in your opinion, this merger guidelines, although they are a draft still, would they be more convincing for judges, even though they're not yet adopted, as arguments for further challenges that the DOJ and FTC made on future mergers? And a second point, if those mergers are, these merger guidelines is adopted as it is now, would they be enough in a sense to oppose to other cases, previous cases, as you mentioned, other case law that may be contradictory to the new view that is provided by the merger guidelines? I would like to see your sense about this future perspective, even though it's not legislation or case law of these guidelines. Thank you.
So the agencies in 2020 came up with the vertical merger guidelines, okay, which were in part a response to losing AT&T Time Warner by the DOJ, actually, okay. At the time, the 2 Democratic members of the FTC voted against them, okay, and the Republicans were still in charge, and this was during the Trump administration, 2020, and now we've gone substantially different than that. Okay, this is a much, in particular. Okay, so this is guideline 5 is the one that's relevant for one of the 3 related verticals. So I think overall guideline 5 is basically sound, okay, and is more pro-enforcement, is more skeptical of vertical efficiencies than the 2020 guidelines. So that might help the agencies in court. The problem they face, though, and I testified for DOJ in the AT&T Time Warner case, which went badly for them and me, I should say, given the judge. The problem is there's no structural presumption, there's no shortcut in a vertical merger for the agency. So you have to convince a judge that it's reasonably likely, probable, that some bad effects will happen. I tried to do that in AT&T Time Warner. AT&T and their experts fought back and said, well, you didn't measure this right, you can't show that, this other thing's unlikely, the world's changing, whatever. And it's very hard to, that's a challenge, that's an evidentiary challenge, it's a hurdle. The guidelines cannot when pretty much no matter what you write in the guidelines, you still face that challenge. What you can do in guidelines is write some convincing language, like, look, here are the sort of things, if we see this, we think that's convincing that there's likely to be a problem, even though we can't measure this, or the world's uncertain, or whatever. That sort of thing, which is what I would do writing these things. I think they've done some of that, so that'll help. But it's also about case selection. I mean, the United Change case was, the vertical part there was about leakage of confidential information from one side to the other. Well, and then the defending company said, we promise not to do that. We have a way of doing it. So it's just like a fact-based, like, is that going to happen? The judge said, I don't think it's going to happen. So you lose, government. And in Microsoft Activision, I just think it's from that seemed like questionable case selection as well. So we have a small number of cases. The government loses. It doesn't mean their theory is wrong or the enforcement. It just, was that the right case to bring? Or you may get bad luck with a judge. This is just small numbers and what happens. Okay, so okay, thank you,
Carl. This is great. I want to thank you for your commentary. I want to thank everyone for questions, and everybody else who didn't ask a question but had one in their head, simply for listening. We also have this online, so for whoever couldn't make it and is watching it now, it is just as fresh and interesting, because 120 years later, antitrust is still vibrant in the United States, sometimes in interesting ways, sometimes in ways we thought would hopefully be not so interesting. But there's a lot going on, and there are many applications to Latin America. Julian, I send it back to you.
Thank you very much.
Thank you all. I also want to thank you all for coming. Hopefully this was helpful. Thank you.
Yes, in fact, I was going to give a call. We have a tradition to give the guest speaker the final conclusion. I'm going to say something else, or we're very thankful for both you and Danny. It was great to hear both of you.
Let me just say, I really thank you. I appreciate you taking the time. If you have an interesting story or vignette from your experience, send me an email. I'm easy to find. That way I could learn about how all this we're doing in the United States is affecting you, hopefully positively, but not necessarily. Thank you.
Thank you very much, and I'll see you all on the next breakfast is in a topic that is related. Rachel Brandenberger will be speaking about whether there is a convergence or divergence between Europe and the United States. So that will be on November 21st. I look forward to seeing you all. Thank you very much. Bye.
Thank you. Bye.